My name is Ravi. I'm from Armchair Criminal. I welcome you all to this part of the program. This is the second section, the exceptions to the hearsay rule pursuant to section 118. In this part of the section, we will consider res gestae, which is rule 4 in section 118. By way of introduction, I would say that res gestae is the fourth rule in common law exceptions to the hearsay rule that has been preserved under section 118 of the 2003 Act. This topic has evolved and expanded beyond recognition from the days in which it first came to existence. This is an important topic, but sadly misunderstood, especially by those who practice in the magistrate's court. I am horrified to understand from some of my colleagues that there's a particular magistrate's court who would question the defense advocate for asking the prosecution witnesses to attend court when the prosecution claims that there is res gestae. They can't understand. The court appears to be under the misapprehension that if there is res gestae, that is all needed. Why do we need any more? Really? Ask yourself, how would the defense challenge the evidence? What has happened to right to a fair trial? Right to confront the accuser? How do we test whether it is res gestae? What other things could have gone into making that statement? So therefore, it is a fallacy to believe that res gestae is the only piece of evidence that is needed to prove an allegation. Such misunderstanding undoubtedly would cause injustice to the defendant, to other parties, and the community at large. It is that fear caused me to treat this topic of its own right and to create this part of the program. I hope through this program we would be able to overcome some of the misunderstanding in the application of the res gestae rule. As I said, this would be a 4-part series. We will look at 1. Key elements in the legislation and the birth of the rule. 2. The development of the rule in res gestae. 3. We will analyze the concept of res gestae. And 4thly, hopefully we will be able to get rid of some of the misunderstanding in the application of the rule in res gestae. Before we go any further, a correction needs to be made. When I did the first section and introduced section 118, in which I referred to res gestae, I used the word emotionally empowered. In fact, it is emotionally overpowered. I'm sorry for the error that I made, but I want to correct that here and now. So from there, let's ask ourselves, which I have been asking myself, how well best to understand res gestae? Honestly, I feel it is almost impossible to give a global view of the application of res gestae. The best way to understand and to do justice is to look at the concept of res gestae and the application of that rule in the context of the proposed evidence under res gestae. Next, I propose to consider the key elements of res gestae. So let's ask ourselves, what does the legislation say? Res gestae Rule 4. Any rule of law under which, in criminal proceedings, a statement is admissible as evidence of any matter stated if A. The statement was made by a person so emotionally overpowered by an event that the possibility of concoction or distortion can be disregarded. B. The statement accompanied an act which can be properly evaluated as evidence only if considered in conjunction with the statement, or the statement relates to physical sensation or a mental state such as intention or emotion. So, when one considers, it is important to look at whether the person was emotionally so overpowered to exclude the possibility of concoction, fabrication, or distortion of the events. Generally, the statement would be accompanied by an act so that it could be evaluated in conjunction with the act and the statement together. The statement should relate to the physical sensation or the mental state. Next, how best to understand res gestae? As I said earlier, look at the whole problem in the context that it comes to light. It is important to understand that because the whole concept is based on the philosophy that if a person is so overpowered by emotions and there is no opportunity to fabricate, concoct, exaggerate, distort, then the material that the person is providing, the statement that he or she is making, is more likely to be true. With that, there is the actions one could look at to analyze what is being said. So, when you look at Rule 4A, just to reiterate, any rule of law under which, in criminal proceedings, a statement is admissible as evidence of any matter stated if A. The statement was made by a person so emotionally overpowered by an event. Something happens and just reacts, giving a statement. That is what is meant by that the possibility of concoction or distortion can be disregarded. Next is subparagraph B, the statement accompanied by an act which can properly evaluated as evidence if considered in conjunction with the statement. That is why I said the statement and the action to be looked at together. But not always there need to be some form of action that is needed. In other words, the statement need not always be accompanied by an act. There could be instances. When we look at cases, we will see that. Paragraph C, the statement relates to a physical sensation or a mental state, such as intention or emotion. That is important to understand because when one considers the whole concept, a person may be expressing physical sensations or a mental state through that res gestae concept. In other words, expressing how that person is literally feeling at the time. And that could be important. I do not propose to take the matter any further at this stage because my object here was to analyze the relevant rule here in detail, which we have done, and we will expand this in part 2 when we look at the concept of res gestae, how it has developed, and move on from there. Thank you for your valuable time. I hope the introduction has been of use, and I look forward to meeting you again. God bless.